Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 2 immigration shows every week on Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English and on Friday at 6 p.m. EST with attorney Balu Indra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration, law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is H1B, RFEs and updates on registration. We will continue the knowledge session along with the news and updates on latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello Ms. Prashanthi, how are you?
Hi Tony, I'm good. How are you?
Very well, thank you. So, Ms. Reddy, before we get on to the topic, do we have any latest immigration updates this week? And the visa bulletin has come up, so updates from that as well?
Yes, so let's start with the updates with the visa bulletin because this is kind of hot off the press.
Right.
The visa bulletin just came out today and there was a lot of anticipation for this visa bulletin. So let's just go through all the changes in the visa bulletin and see if there's any forward movement. So starting off with the family-based cases, unmarried children of US citizens, there is a change of 1 month for Mexican nationals, no change for Indian nationals or any other nationals. Spouses, unmarried children under the age of 21 of permanent residents, no change whatsoever. With reference to unmarried children of green card holders or permanent residents, change of 21 days, meaning it's moved 21 days for Mexico. And then for married children of US citizens, it's moved 1 year. There's a lot of movement for Mexico for some reason, no movement for India or China or any other country. Philippines has a 1 month forward movement. Siblings of US citizens, that is if you're a US citizen and you're filing for your brother, sister. India, there's a movement of 1 month and 7 days, and Mexico 3 months, Philippines 2 months. So that's the movement for US citizen if you're filing for your siblings. Now remember this, what we're talking about here is the dates for filing. There's not much change. As all of you know, in the visa bulletin, there are 2 categories of charts. One is dates for filing and one is final action dates. So in the final action date, there's not much movement. So we're only talking about dates for filing right now, and we're hoping that by tomorrow we will know if USCIS intends to use this dates for filing chart or not. The reason I'm saying there is a lot of forward movement is because as we're coming to the employment-based, we will see a big change. So coming to employment-based now, EB1, no change. So that's EB1 extraordinary ability, or if you're filing based on an L1. EB2 is where there is significant change. So for Indian nationals, it's moved up by 1 year. So it's moved from September 2013 to September 2014. So if you have a priority date that is on September 2014 or before, you can now get ready to file your 485 as of April 1st. So make sure you get everything ready. So that is the biggest change, I think, in this dates for filing chart for this month. It's been moving. EB2 India has been moving rapidly. It moved 4 months last month. It moved by 6 months in January, and now we're seeing a 1 year movement. So that's pretty significant. For EB3, there's not really much change. And other categories, there's not much change. So the main, I think, takeaway here for the visa bulletin is that all those who have EB2 cases, if you have downgraded in October, where most of you must have, a lot of people had EB2s to start off with, and then in October, since EB3 was a better date at that time, that had become current, a lot of people switched, downgraded their I-140 from EB2 to EB3. And so now for those people, if your date is current based on EB2, it would be a good time to interfile or file a duplicate 485, and you have to discuss with your attorney which one is better. Or if you have not filed at all and now your dates are current, it's of course a good time to file, for your EB2. So that's important. Now remember, one thing I forgot to mention is this is dates for filing, which I did mention that. So we have to wait and see whether this calendar is good or not. And I did mention earlier about interfiling. Please remember, you can only interfile based on final action dates. So we haven't got into the final action dates chart because there's not much change there's a 2 months change in EB2. So it's moved ahead 2 months for final action date. So if your date is current, go ahead and do the interfiling. Or you can do a duplicate filing if you are only current based on dates for filing. Final action date, you can do interfiling or duplicate filing. If you're current only based on dates for filing charts, I know this is confusing, but for people who know what I'm talking about, they will understand. So if you are current based on dates for filing, then you can do only a duplicate filing. You cannot interfile. So we talked about interfiling earlier as to what it is. So interfiling is basically we're asking USCIS to use the other I-140 we have, and so that we don't have to refile the 485 all over again, use the existing 485 that we have. So that's, I think, the update. Also, please remember to get your documents ready. If, this dates for filing chart, if they say that we were able to use it, and I think we will be because this chart has been in use for a few months now. Get all your documents ready, get your medicals ready before April 1st. There's a lot of work for you to do, so get your medicals ready. Make sure you have your birth certificates. If you don't have birth certificates, make sure you have birth affidavits from people who were present at the time of your birth, and these have to be notarized. If those people are in India, then it has to be notarized and on stamp paper. So there's some work to be done. Make sure you have all your I-94s, download them from the I-94 website, USCIS website, your marriage certificate if you're married, your children's birth certificates. That's the most important thing that people usually struggle with, medicals and birth certificates. The rest you should have, hopefully, with you. So, get everything ready. Talk to an attorney. I don't suggest filing yourself because so many things can happen. Unpleasant things can happen if you do file yourself, and this is just heartfelt advice. Don't do it yourself. But find an attorney that's reasonable and good and is able to take up your work, because it has to be filed within a certain period of time. It has to be filed in the month of April. So you have 30 days or 31 days to file your case. So that's the update with reference to the visa bulletin, Tony.
Right. So, it being the season for H1B registration updates, the registration is happening in full swing. Do we have any updates over there?
Yes, there are just a few updates. One is we had some issues with the website yesterday. So the fun continues, the excitement. When you try to log in and you can't, then you have a panic attack. But so that's happened a couple of times yesterday. Today, the website seems to be functioning smoothly. I guess it's just the number of people that are filing registrations. Maybe the website is not able to take the volume sometimes, or they're making some updates, and that's why it's not functioning for a short period of time. My advice would be to file as soon as possible if you already haven't filed. The deadline is Friday, 12 p.m. So that's 12 noon, not 12 early morning. So usually people would think that if the deadline is Friday, that means it's until 12 a.m. It's not, it's until 12 p.m. noon. So my advice to you is that you should have already filed, but if you haven't for some reason, then please file at least by tomorrow afternoon, because you want to give yourself some time in case of the website not working, login not working, so anything might happen. So you want to make sure that you do that. So again, to mention the deadline, it's the 18th, which is Friday, 12 noon. And after that, once the submissions are done, we'll start getting the results between Monday and April 1st is when we'll start getting results. So you'll see so between 21st and 31st, you'll start the next 10 days you will see whether your cases have been picked or not, and the results are usually staggered. They'll come over a period of time. Everything won't come in one day because it takes time, I guess, for them to send out the notices, and they send out the notices via the portal. And you'll also get an email saying that there's some changes made to your portal. So that's your cue to go and check your portal to see what changes have been made, what cases have been picked that particular day. And April 1st, another big date to remember is April 1st. That's the date when you can actually start filing your H1B petitions. And another date to remember is the 90 days deadline from April 1st. So June 30th is another date to remember. That's the date when all H1s from the first lottery have to reach USCIS. And if that is a weekend, then it can reach on the following business day, but I wouldn't wait until the last minute to send it again. So that's the update, attorney, for the registrations.
H1 registrations, right. So with that, we'll just get back to the topic, which is H1 RFEs, and what can we expect as the RFEs for H1 registration?
So we now that most of the registrations have been done, the next step is filing your H1. So I thought this would be a good cue for me to talk about how to avoid an RFE, really.
Right.
That's what we want to talk about.
Right.
Because when we have to try avoiding RFEs with the filing of the petition. So you have to file a perfect petition or near perfect petition, or as perfect as it can get. There is no perfect petition, but file as much as you can, be as detailed as you can to avoid an RFE. Why should you avoid an RFE? Because an RFE could lead to a denial. Right. And instead of asking one thing, they can ask 10 other things. It's like opening a Pandora's box. So that you want to try to avoid that. Also, the processing time becomes much longer once you get an RFE. So those are the many reasons why, and there's additional work and time for you and time for the attorney to respond to the RFE. It's a lot of work. So we want to try to avoid getting an RFE, and the way to avoid that is by at least knowing what the common reasons are to get an RFE and trying to avoid that. So the foremost and biggest reason is they might send an RFE saying that your occupation that you're filing for is not a specialty occupation. So in order to qualify for H1, the petition must demonstrate to USCIS that it's a specialty occupation. So you have to show evidence that the job is one that requires not only the understanding and application of a highly specialized body of knowledge, but also that that particular job normally requires a bachelor's degree, or it's equivalent in that particular field. So what's been happening is in recent years, USCIS has narrowed its interpretation of what is a specialty occupation, and there have been many jobs that have been removed, so to say. There's no list of specialty occupations, but USCIS doesn't think some positions are specialty occupations anymore, like programmer analyst, systems analyst, computer programmer, a market research analyst in some cases, though that is changing slowly. So the USCIS often challenges these positions, and they send out RFEs asking for detailed job descriptions, proof to show that it's complex enough to require a bachelor's degree, like a list of duties and what educational and experience is required for this job. They want to see in the industry what is the common education and experience required. So this is a painful RFE simply because also they want to see that there's a link between the job description and the education that the person has performed or the educational requirements of the position. So say you require a computer science degree for a computer programmer position, they want to make sure that is relevant to that particular job. So it's a big list of documents you have to provide, a lot of explanation, and what would be useful is to get an evaluation done. So if you are kind of filing a H1 for a borderline specialty occupation case, I wouldn't be a bad idea to do an expert opinion evaluation. So an evaluation from a professor, and give that professor the duties and give them the requirements of your company, give them the qualifications, and ask them to write a memo on whether they think that the particular job that you're filing for requires a bachelor's degree or not in a specific field. So that could really help not get an RFE. So that's definitely one way of avoiding an RFE, especially in job positions which are likely to get specialty occupation RFEs. Another reason to get an RFE would be availability of work. Now, H1B's beneficiaries working, especially at third-party work sites. If you're an IT company, you're placing the person at an end client site. They want to see that the beneficiary will be engaged in specific, non-speculative work in a specialty occupation for that period of time that you're asking the H1 for. So it cannot be speculative employment. You cannot say that, you know what, I'm going to get the H1 for the person and then I'm going to look for a job for them later. And in the meantime, I'm going to put them on the payroll. But they'll be dormant. They won't be doing any work. Unfortunately, USCIS used to allow that. They're not allowing that anymore. They want to see that you actually have a job for the person in a specialty occupation before you actually start, when you're filing the H1 itself. So in order to prove that, USCIS is asking for contracts to show that the work is not anticipated, and other documents to show that there's a steady workflow, that you have enough work for them, like signed contracts, detailed work assignments, work orders, end user letters, etc., etc. So they are asking for this. They don't need as much detail as they used to. There's been some reform in this area because earlier it used to be much worse, but now anything that you have, just a PO, a purchase order, a letter, and anything to show that you have a job for this person will be sufficient. Now, another reason why they would send out an RFE. So then how do you avoid that where it comes to speculative work, availability of work? Make sure with your H1 you're sending out your contracts, your POs, letter from the vendor, letter from the client, whatever you have, to show that you actually have a job. Don't wait to get an RFE and to send out that information. So make sure you send it out, even if it's an email from a client. If you don't have a letter, that's fine as well. So that's how you can avoid. If you don't send that, for sure you will get an RFE, and then they will ask for a bunch of other things, as I just mentioned. Another reason you might get an RFE is for the beneficiary's qualifications. Now you have to show that the beneficiary not only is working in a specialty occupation, but has the required credentials to work in that occupation. So the employer must show that the beneficiary holds at least a bachelor's degree in that field, or in the alternative, the beneficiary has a sufficient combination of work experience and training, or a licensure to engage in that specialty occupation. So it either has to be degree or a combination of work experience and degree, or a license. Say if you're going to be working as a doctor, you have to show that you're licensed as a doctor. And you don't need to really show a degree or anything like that, because the requirement is the license. So if the beneficiary in this case doesn't have a degree in that specialty occupation, then they have to look through to the work experience. And so how do you avoid an RFE here? Make sure you send out that degree copy with all the transcripts if he has a relevant degree. Make sure you have sent the transcripts as well, because just saying bachelor's in science doesn't really show what he's done a bachelor's in. And the mark sheets or the transcripts will show the computer courses that that person has, and show that he's qualified as a computer professional. So transcripts are very important. Also, an evaluation might be necessary, especially if the person has a foreign degree. You might want to get an evaluation of the person's educational credentials. Sometimes if he doesn't have a straight 4-year degree, maybe he only has a 3-year degree, like a BSc Computer Science from India, then you'd have to show a combination of at least 3 years of work experience and that 3-year degree, combining it together, get an evaluation done, and they'll give you the equivalent of a bachelor's degree. So 3 years of work experience is equivalent to 1 year of degree. That's the formula they use. So the combination of the 3-year degree plus the 1 year, the work experience, 3-year work experience equivalent to one year of college will be a total of 4 years. Because here in the US, a bachelor's degree is usually 4 years. So in that case, you wouldn't wait to get the RFE. You would send an evaluation out, a work experience evaluation, education and work experience evaluation in the first instance with the H1 to avoid an RFE. Another common reason to get an RFE is maintenance of status. Now, they always issue RFEs because you cannot, especially if you're filing for an extension, or you're filing for a change of status, or you're filing for a transfer, they want to make sure that you are presently in status. Otherwise, they cannot issue you the H1. If you're filing for consular processing, which means that if you're not in the country or you're willing to leave the country and, go to the consulate, get a visa and come back in, then they will not, ask you for documents to show that you're in status. Otherwise, you have to provide, the I-94s to show you're in status, all the I-797 approvals, pay stubs. If you're presently on a H1, it's not just a H1 approval, but to show that you're actually working on a H1, you have to actually submit pay stubs from your present employer, verification letters, etc., etc. Now, make sure you submit this again. This is all basic information. If you don't submit it, you'll get an RFE. So make sure you submit all this information. Sometimes, even if you send out the I-94s and all the basic documentation, you might still get an RFE, especially if it's a maintenance of status issue related to a student. So when you're a student and if you're on CPT or OPT, they want to make sure that you maintain your status on OPT, on optional practical training, which means they want to make sure that you have actually worked on optional practical training, that you have met all the requirements. There are certain rules with reference to the CPT and OPT. So they want to, then they will asked for documentation from the school or from your employer to show that you've actually worked for the required number of hours. So that's the maintenance of status in conjunction with, being on an F1 status and filing a change of status from F to H. Now, the other thing, another important thing is the LCA, Labor Condition Application. That's a document that you have to get approved from the Labor Department. It takes about 5 to 7 business days, and once that gets approved, only then can you file your petition with, USCIS. Now, everything on that application has to correspond, or on that approval has to correspond with your petition that you're filing, the H1 petition that you're filing with USCIS. If it doesn't, you will get an RFE. So make sure that your LCA is correct. And if you see any errors in the LCA, your case will get an RFE and will get denied because you cannot correct those errors. You cannot file a new LCA at that time. You have to refile your LCA and the petition. So very important review your LCA, look for typos, look for any information. The important information such as your address, the name of the client is usually there if there is a client, the address of the client is usually there, and there is information as to whether this case is an extension, transfer, amendment, etc. So make sure that you're using the right wage level. We always have issues if we use wage level 1, especially if it's an experienced person. They want you to use wage level 2 or 3. Again, that's a red flag and cause to get an RFE. So make sure if you can to use the proper wage level. Another reason, I think this is the last but not the least, of the reasons to get an RFE is the AC21 or the 6-year limit. So H1s are given only for 6 years. And sometimes if you ask for a H1 beyond 6 years, you might get an RFE unless you submit the proper documentation beforehand to show that you're eligible to get an extension beyond 6 years. And there's only some instances in which you can get that extension. That is if you have a pending labor certification that's been pending for a year or more, or you have an I-140 approval, or an I-140 pending for a year or more. So in those instances, you can get further extensions on your H1. And last but not the least, I know I said the previous one was the last, but last but not the least is the fees. Even though this seems like a no-brainer that you have to pay the right fee, it's very complicated to calculate the USCIS fee. And sometimes even attorneys get confused. So make sure you know what your fee is. And this is a whole topic for another day as to what the fee is for what kind of companies, what size of companies. So just make sure you know what the fees are. And of course, don't make typographical errors on your check when you're writing it down. Write the correct word, sign it, correct amount, etc.
Right. So, Ms. Reddy, with that, you've explained everything about how to avoid RFEs. But let's say, just in case somebody gets an RFE, what are the best practices?
Right. So best practices, read the RFE carefully. If you don't understand, of course, ask an immigration attorney. Again, don't attempt to do this on your own. Read it carefully because sometimes there's a lot of information that's between the lines and they don't say it clearly because they're not the best at telling you what they want. Sometimes you have to guess, and that only comes with experience. Only people who are experienced will know what documents to send if they ask for something on the RFE. So read it carefully. Don't panic. Don't make any rash decisions. Simply because you've received an RFE, it doesn't mean that it's a denial. It's just that the USCIS needs more information, so there's no need to panic. Don't answer the RFE in bits and pieces. Answer every single question that they're asking. If you choose to answer 2 out of 5 things that they're asking for, you will get a denial. You will not get a second RFE. So make sure you answer all the questions that they're asking thoroughly. Make sure you send it to the right address. Double check and make sure you've included all the documents, right? And then most importantly, submit your response before the deadline period ends. Don't waste until last minute because sometimes, remember it has to reach USCIS by that deadline period. So it's not when you mail it, it's when they receive it. So you don't have control over the mailing services, even if you send it by UPS or FedEx. Sometimes things happen. So make sure you send out your RFE at least a week in advance. Just to add to that, with COVID-19, there are some extra 60 days grace that we're getting on top of the date on the RFE. So there is some, leeway there, but, just don't wait for the last minute.
Right. So with that, Ms. Reddy, we come to the end of our session. Thank you for all your valuable insights and all the information you've given us regarding the RFEs and what to avoid, what not to do, and what are the best practices in case you just get one. And I hope our viewers are taking notes. So it's a pleasure having on the show as always, Ms. Reddy. Thank you.
Thank you, Thorni. Take care.
You
Bye.
too. You're watching Sakshi TV. This is Thorni. Thank you.